Right now, the United States has crossed into territory no president, no court, and no Congress has ever entered before. A federal judge has just taken an action that has never occurred in American history. While a federal criminal trial was still actively underway, that judge formally transmitted impeachment evidence directly to the United States Congress. Not a summary, not an opinion, not a recommendation, the evidence itself. This did not happen during Watergate. It did not happen to Nixon. It did not happen during Clinton. It has never happened until now. And tonight, Washington is reacting as if it understands exactly what this means. National Guard units are deploying across the Capitol. Security perimeters are going up. Lawmakers are being briefed behind closed doors. And the political system is moving at emergency speed. This is not politics. This is not cable news drama. This is a constitutional system activating under extreme stress. Just hours before this unprecedented judicial referral, something else happened that shocked even veteran court watchers. Federal marshals physically removed Donald Trump's entire legal team from a federal courtroom in full view of cameras. For perjury, let that sink in. Not misconduct, not decorum violations, perjury under oath. And instead of simply continuing the trial, the judge escalated. He made a decision that instantly collapsed timelines that presidents have relied on for decades. Delay is gone, stalling is gone. The clock is now judicial, not political. If you are wondering why everything suddenly feels different tonight, this is why. Because when a federal judge sends impeachment evidence to Congress while a trial is still live, it signals one thing and one thing only. The conduct is so severe that normal separation of powers can no longer absorb it. And this is only the opening move. Over the next 72 hours, Congress will be forced to act. Political alliances will fracture, evidence will surface, and pressure will intensify on institutions that rarely face moments this stark. Stay with me, because what you are about to hear explains why impeachment is no longer a theory, why Washington is preparing for instability, and why the next 3 days may permanently redefine the presidency. And before we go any further, make sure you are subscribed. This story is moving fast, it is escalating by the hour, and what comes next will not slow down. What happened inside that federal courtroom was not disorder. It was not chaos. It was control. And that distinction matters, because when federal marshals moved toward Donald Trump's legal team, this was not a spontaneous reaction. It was the final step in a process that had already reached its limit. The judge had warned them. The court record shows it multiple times. Under oath, Trump's attorneys repeatedly denied the existence of specific emails. Not once, not twice, 17 separate times. They told the court those communications did not exist. They told the judge there was no record. They told the jury there was nothing to see. But the evidence said otherwise. What the court already had in its possession directly contradicted those sworn statements: emails, metadata, financial records. When the judge confronted the defense, there was no clarification. There was no correction. There was no attempt to walk anything back. The lies continued. At that moment, the trial did not merely pause, it changed direction. The judge ruled that the defense had crossed from advocacy into criminal conduct. Perjury is not a tactical error. It is a felony. And so the order was given. Federal marshals approached the defense table. They instructed Trump's attorneys to stand. They were escorted out of the courtroom, not quietly, not privately, in full view of cameras, in full view of the jury, in full view of the public. This was not symbolic, it was procedural enforcement. And here's where the story takes its most dangerous turn. Instead of simply appointing new counsel and continuing the trial, the judge did something no federal judge has ever done before in real time. He stopped, he assessed, and he escalated, because what the court was now facing was not just perjury, it was obstruction of justice tied directly to a sitting president. When lawyers lie under oath to shield a client, the court must determine whether that conduct was directed, whether it was coordinated, whether it was part of a broader effort to interfere with judicial authority. Those questions cannot be ignored. At that moment, the courtroom ceased to be just a venue for a criminal trial. It became the trigger point for a constitutional confrontation. And this is where you need to understand something crucial. Judges are trained to avoid politics at all costs. They do not escalate unless they believe the system itself is being compromised. That threshold was crossed in that room. And if you think this ends with lawyers being removed, you are missing what is coming next. Because once a court determines that obstruction and perjury may be connected to executive authority, the judiciary is no longer allowed to stay silent. Stay with me. The next move the judge made changed everything. And if you want to understand how this courtroom moment exploded into a national crisis, make sure you are subscribed, because what comes next is the reason Washington is now operating under emergency conditions. What happened next
is the moment everything broke open. After the courtroom was cleared, after the defense was removed, the judge did not recess for the day. He did not call for new counsel. He did not simply move on. Instead, he issued a formal judicial order. And the language inside that order was explosive. The judge wrote that obstruction of justice and perjury constitute impeachable high crimes and misdemeanors, not hypothetically, not academically,
in connection with the conduct before the court. Then came the line that sent shockwaves through Washington. The judge stated that congressional transmission was now complete. That phrase is not rhetoric. It is procedure. It means the court formally assembled evidence, certified it, and transmitted it directly to the House of Representatives for impeachment proceedings. Not a summary, not a referral memo, everything. The full courtroom transcripts documenting 17 separate lies under oath. The emails the defense claimed did not exist, including the $40 million Saudi-linked payment email that directly contradicted sworn testimony. Body camera footage showing federal marshals escorting Trump's legal team out of the courtroom, time-stamped, cataloged, authenticated, and then came the recordings. Recordings that were never meant to be heard publicly. A recording in which Donald Trump is heard instructing associates to ignore court orders. A separate recording in which Trump is heard threatening judges. These were not leaks. They were not media scoops. They were exhibits. Every piece of material was sealed, indexed, and delivered directly to the House Judiciary Committee. This has never happened before. During Watergate, Congress investigated. During Nixon, courts waited. During Clinton, political branches handled accountability. Here, the judiciary stepped directly into the constitutional machinery and said this conduct cannot wait. That decision matters more than any single piece of evidence because courts do not do this unless they believe delay itself poses a danger to the rule of law. Presidents have survived scandals for decades by running out the clock. Litigate, appeal, delay, let public attention fade. That option is now gone. By transmitting impeachment evidence mid-trial, the judge collapsed timelines that normally stretch for years into days. Congress is no longer operating on political convenience. It is operating on a judicial clock. And once that clock starts, it does not pause for rallies, polling, or threats. If you are wondering why lawmakers suddenly look panicked, this is why. If you are wondering why security is tightening across Washington, this is why. Because when a federal judge declares that impeachment-level conduct is documented and complete, the system is forced to move. Stay with me because the next piece explains why Congress was already loaded for this moment and why impeachment did not begin yesterday. And before you go anywhere, subscribe. You are watching a constitutional process activate in real time, and what comes next is where the numbers make this unavoidable. Here is the part many people are only now beginning to understand. What happened in that courtroom did not create impeachment. It activated it because Congress was already prepared. Long before the judge transmitted his evidence, a House impeachment resolution had been quietly sitting in place, not rushed, not reactionary, dormant but complete. House Resolution 2353, 7 articles, fully drafted, legally structured, waiting. Those articles were not symbolic. They were not vague. They were specific, severe, and designed for a moment exactly like this. Bribery connected to emoluments violations, abuse of power tied to misuse of executive authority, obstruction of justice, contempt of Congress, violation of the oath of office, incitement, and conduct linked to military deployment discussions that lawmakers privately described as tyrannical. For months, that resolution sat without the votes to move. It had support, but not enough. Mostly Democrats. A handful of Republicans, roughly 120 co-sponsors. That was not sufficient, and leadership knew it. Impeachment does not move on outrage. It moves on arithmetic. Everything changed the moment the judge's referral landed. Because the referral did not add allegations, it added evidence. Evidence certified by a federal court. Evidence assembled under oath. Evidence that removed plausible deniability. By the next morning, lawmakers who had been sitting on the fence were no longer debating politics. They were assessing exposure. Could they defend this on television? Could they explain it to voters? Could they justify silence now that transcripts, recordings, and body camera footage existed? The answer for many was no. Names began to appear on the resolution at speed, not quietly, publicly. Republicans who had defended Trump days earlier began adding their signatures. Some issued statements, some did not. But the count kept climbing. By midday, the number crossed a line that cannot be uncrossed. 220 co-sponsors. That is not momentum. That is a majority of the House of Representatives. At that point, impeachment stopped being a threat. It became math. Leadership did not need to whip votes. They did not need backroom deals. The votes were already on paper. This is why the tone in Washington shifted so suddenly, because when the numbers are there, delay becomes dangerous. And this is where the process accelerates, because House rules contain a mechanism for moments when leadership believes delay itself poses a risk to the country. That mechanism has now been invoked. Stay with me. The next section explains why the clock is now measured in hours, not weeks, and why Republicans are defecting in real time. And if you want to understand how fast this is moving and why there may be no off-ramp left, make sure you are subscribed. You are watching a system move once the numbers lock in. This is the moment the Republican Party began to fracture in public, not in theory, not in anonymous leaks, in names, in signatures, in statements that cannot be walked back. Until now, many Republican lawmakers had followed a familiar strategy: wait, deflect, question motives, avoid committing either way. That strategy collapsed the moment the judge's evidence arrived. Because this was no longer about defending a president. It was about defending the indefensible. The recordings changed everything. The transcripts removed ambiguity. The image of Trump's lawyers being physically escorted out of a courtroom for perjury destroyed the last line of rhetorical defense. You cannot spin that on television. You cannot dismiss it as partisan. You cannot explain it away as a misunderstanding. Republican lawmakers understood this immediately. And then came the defections, not from fringe figures, from names that had defended Trump publicly and repeatedly. Some held press conferences, some released short statements, some simply signed the resolution and said nothing at all. But the message was unmistakable. Resign or face removal. Unfit to command. This cannot continue. When members of a president's own party begin using that language, it signals something deeper than disagreement. It signals fear, fear of evidence, fear of association, fear of being the last person standing next to a collapsing structure. Lawmakers are trained to read risk. They are trained to sense when the political ground is shifting beneath them. And what they saw was this. Every additional piece of evidence made defense more dangerous than defection. Every hour of silence increased personal exposure. Every attempt to downplay the situation was instantly contradicted by court-certified material. This is how loyalty breaks. Not all at once, but fast. Behind closed doors, conversations turn blunt. Can you defend this in a campaign ad? Can you justify this under oath? Can you explain why you stood by while judges were threatened and court orders were ignored? For many, the answer was no. And once defections begin, they do not reverse. Others follow not because they suddenly change their beliefs, but because survival demands alignment with reality. That is why the list keeps growing. That is why party leadership is scrambling. And that is why the president's circle is shrinking by the hour. If you think this is about ideology, you are missing it. This is about self-preservation. Stay with me, because as Republicans abandon ship inside Congress, the president himself is reacting in a way that is making his legal exposure exponentially worse. And before you go anywhere, subscribe. You are watching a political implosion unfold in real time, and the next phase is where restraint disappears. As Congress begins to move, the president is doing the one thing that is making everything worse. He cannot stop talking. Since the judicial referral landed, Donald Trump has been posting continuously on social media. Not measured responses, not strategic statements, rants, all caps, personal attacks, accusations of hoaxes, threats, conspiracies layered on top of conspiracies. At first glance, this looks familiar. Trump has always lashed out under pressure. But this time is different because every post is now evidence. Every message is time-stamped, archived, preserved. When a president attacks judges while under active judicial review, it is no longer rhetoric. It is witness intimidation. When a president calls for resistance to Congress exercising constitutional authority, it is no longer speech. It is incitement. And then came the post that set off alarms across Washington, a direct threat of civil war if Congress removes him. That sentence matters. A sitting president threatening civil war in response to impeachment is not political hyperbole. It is a red line. Law enforcement agencies treat statements like that as signals, not opinions, signals. That is why intelligence units are now monitoring extremist communications. That is why security posture shifted overnight. That is why contingency plans are being activated. Trump's allies understand this, even if they will not say it publicly. They are watching his behavior move from defiant to erratic, from aggressive to destabilizing. And the danger is not just political. From a legal perspective, Trump is building a record that prosecutors could not have scripted better. Threats against judges strengthen obstruction cases. Calls to defy Congress bolster contempt allegations. Apocalyptic language supports arguments about instability and fitness for office. He is not defending himself. He is narrating his own exposure. This is what unraveling looks like in real time. A president who once relied on ambiguity is now creating clarity. A president who once relied on delay is now accelerating consequences, and Washington sees it. Behind the scenes, officials are not debating whether Trump is escalating. They are planning around the assumption that he will continue to escalate. That is why restraint is gone. That is why patience has evaporated. That is why institutions are hardening rather than hesitating. Stay with me. Because Trump's behavior is not happening in a vacuum. It is directly connected to why Washington is now locked down, why the National Guard has been deployed, and why the next phase of this crisis moves from rhetoric to readiness. And before you move on, subscribe. You are witnessing a moment when words stop being noise and start becoming triggers. Washington is no longer operating under normal conditions. This is not a drill. This is not symbolic. National Guard units have been deployed across the Capitol. Barricades are going up around key government buildings. Security perimeters are expanding by the hour. Law enforcement presence is everywhere. Officials are not reacting to protests. They are reacting to risk. On the streets, two Americas are beginning to form in real time. Pro-Trump groups are gathering, shouting claims of persecution and stolen power. Anti-Trump demonstrators are demanding immediate removal, chanting that the rule of law must be enforced. This is not a political rally environment. This is a pressure environment. Authorities remember what happens when rhetoric is ignored. January 6th is not a memory. It is operational knowledge. Agencies know exactly how fast online threats can turn into physical action. They know how quickly misinformation spreads. And they know that when a sitting president uses language like civil war, it changes how people behave. That is why the response is layered. Uniformed presence for visibility, intelligence monitoring for coordination, rapid response units on standby. The goal is deterrence, not confrontation. Inside Washington, the mood is described by officials as tense but focused. No panic, no chaos, preparation. Members of Congress are being advised on movement protocols. Staffers are being told to work remotely. Emergency plans are being reviewed. This is what it looks like when institutions take threats seriously. And make no mistake, they are treating the president's words as a threat environment, not because they want to escalate, but because failure to prepare would be negligence. This is why the tone has shifted so sharply. There is no appetite for delay. There is no tolerance for ambiguity. There is no room for miscalculation. The system is bracing. Stay with me, because while Washington locks down on the outside, something equally serious is unfolding on the inside. Multiple pathways to removal are now moving at the same time. Impeachment is only one of them. And before you go anywhere, subscribe. You are watching a national crisis move from theory to readiness. And the next phase explains why Trump is now boxed in on every front. At this point, it is critical to understand something. Donald Trump is no longer facing a single threat. He is facing multiple mechanisms of removal moving at the same time, and none of them require his cooperation. The first is impeachment. That process is now active, accelerated, and operating on a judicial timeline. Once the House votes, the Constitution mandates the next step, a Senate trial. That trial is not optional. It does not depend on political mood. It triggers automatically. The Chief Justice presides. Evidence is presented. Witnesses can be called. Records enter the public domain under oath. Even if conviction is uncertain numerically, the exposure is guaranteed. But impeachment is only one lane. Parallel to it, criminal investigations are advancing. Evidence transmitted to Congress was also transmitted to prosecutors. Perjury, obstruction of justice, witness intimidation. If prosecutors establish that Trump directed his attorneys to lie under oath, that is suborning perjury, a felony. If court orders were ignored at his direction, that is obstruction, another felony. These cases do not pause for impeachment. Courts do not wait for political outcomes. Grand juries do not stop because a president is angry. Then there is the option no one wanted to discuss but now cannot ignore, the 25th Amendment. Quiet conversations are reportedly taking place between the vice president and cabinet members, not about policy, about capacity.